Hey everyone, today I'm going to talk about how to tell whether someone is an employee or an independent contractor. Why? Why is it important to know whether someone is an employee or an independent contractor? Well, because one of the main reasons would be payment of CPF. For those of you who are watching overseas, CPF is a Central Provident Fund. It's a state pension fund. So for employees, you are required to contribute, you're supposed to make payments towards their CPF. Whereas if they are independent contractors, you're not required to make CPF. Also, if a person is your employee, they will have rights under the Employment Act and the Work Injury Compensation Act, which are not applicable for independent contractors. Also, if a person is an independent contractor, the employer will not be vicariously liable for his negligence or his acts or omissions. For example, if in the employer-employee context, if the employee drives a truck, and knocks someone down, the employer will be legally liable for the employee's actions, even though assuming that it was done in the course of his work. So the employer will be liable to compensate for the damage caused or the medical bills or whatever for the victim who was knocked down by the employee. This is called vicarious liability. So this concept of vicarious liability does not apply for independent contractors. Now, I'm going to talk about some factors that the court will consider when deciding whether a person is an employee or an independent contractor. The first one is control. The English case of Ewens and Noakes stated that an employee is a person who is subject to the command of his master in which he shall do his work. The English case of Collins and Hertfordshire also stated that an employer can not only order or require what is to be done, but also instruct the employee how it is to be done. The next factor that the court will consider is whether the work that is done by the person is an integral part of the business of the employer. In the English case of Harrison Limited and McDonnell and Evans, Lord Denning stated that an employee is employed as part of a business and his work done is an integral part of the business. What is integral? Integral means necessary, important. So if the employee's work is important towards the business, it is more likely that the court will find that he's an employee. In the English case of Commissioner of Payroll Tax and Mary Kay Cosmetics, the court held that this factor, integral part, is inconclusive. In the case of Mary Kay, the company hired certain sales consultants who sold cosmetics to customers. The company had little control over how they performed their duties. And also, the sales consultants were paid by commissions instead of salaries. So, in the Mary Kay case, even though the sales consultants performed an integral part of the business, their sales were necessary or important to the business, the court held that they were not employees. The third thing that the court will consider is the method of payment. An employee is likely to be paid by way of salary rather than tips, commissions, or ad hoc payments. Ad hoc payments means not fixed payments that are not fixed. For example, a band who plays at a nightclub, they may perform once a month, once every 2 months, or whenever the owner of the nightclub requests that they perform. So Also, another factor would be payment for amount of work done. Okay. Sometimes employees are paid for the amount of work done. For example, in a manufacturing business, if they make a certain amount of products, okay, they are paid according to the number of products made. That does not necessarily mean that they are not employees. In the Malaysian case of Mat Juso bin Daud and Syarikat Jaya Semberang Sendirian Berhad, it dealt with a sawyer, a person who saws the timber. He was paid according to the number of logs that he sawed. So even though in that case he was paid according to the number of logs that he sawed, the court held that he was an employee because of the other factors that the court took into consideration. In the English case of Nethermer Limited and Taverner and Gardiner, it was held the workers were paid according to the number of garments sewn by the workers. So even though they were paid according to the number of garments sold, the court in that case held that they were employees. Fourth consideration, obligation to work for only one employer. If the person is contractually obliged to work for only one employer or one company, there's a very high chance that he will be regarded as an employee. It is very common in employment contracts to state that the employee cannot work for any other employers or do any moonlighting. The fifth consideration, working hours. Employees are more likely to work fixed working hours, whether with overtime or not. But this is not a conclusive factor because the court in Employees Provident Fund and MS Alley and Co. held that employees are not required to keep regular hours. The court in that case held that even though the employees were not required to work regular hours, they were nonetheless held to be employees. There was also another case where the persons worked from home and the court also held that they were employees. Next, the sixth factor, overtime. Employees are more likely to be paid overtime because it is a requirement under the Employment Act. It is a right under the Employment Act. Number 7, if a person is contractually entitled to annual leave, holidays, and medical leave, it is highly likely that the person is an employee because these are benefits that are conferred under the Employment Act. The 8th factor, the right to terminate, dismiss, or suspend. If the contract stipulates that the employer is allowed to terminate, dismiss, or suspend the person, it is more likely that the person will be held to be an employee. Number 9, delegation, the right to delegate. If a person is not obliged to work for the employer personally but is allowed to delegate his duties, it is more likely that the court will find that he's an independent contractor. For example, if you pay a cleaner or gardener to clean your office or to tend to your garden, and he has the right, even though you pay him, the cleaner or the gardener, he has the right to get one of his subordinates or employees to do the gardening or cleaning instead, it is more likely that he will be held to be an independent contractor. Number 10, provision of uniforms, accommodation, name cards, items with logos, company logos. These are matters that would highly point towards an employer-employee relationship. Finally, a clause in the employment contract. This is very important. Independent contractor contracts, it is common to specifically state that the person is an independent contractor, that he has sole control over the manner and the means of performing his duties and obligations. There will also usually be a clause that the independent contractor has no authority to obligate or to bind the employer by contract or otherwise. So, the court will look at the totality of the factors, okay, in determining whether a person is an employee or an employer. I will do a second video on the recent case of Public Prosecutor and Jurong Country Club, where the Court of Appeal had to decide whether a person, a gym instructor, was an employee or an independent contractor, because the Central Provident Fund Board, okay, wanted to claim arrears in CPF payments. So thanks for watching this video on the factors that the court will consider in determining whether a person is an employee or an independent contractor.